That's all I have, Your Honor.
Mr. Savage.
Without question, this witness, Your Honor, the report that was delivered at the request of the defense is only known to this witness and to the solicitor because this court instructed that if we were going to test the brain sample, we had to give them a copy. Case law, I believe in South Carolina, is that our testing doesn't have to be shared with anyone for any purpose unless we determine that we are going to use that testing in litigation. So we would object to the testimony of this witness or any other witness about what information our firm has unless we intend to use that in our case in chief. That testing was not done in accordance with Rule 5. The report of the testing was not done in accordance with Rule 5. It was done in accordance with the instructions of this court. So we object to any testimony of this witness regarding the brain exemplar that we had litigation with before we sent it to NMS. In addition to that, Your Honor, this witness is testifying without a report having been provided, and I know the court has ruled on that, but I do want to address that we have a report from the people who actually did the testing of their interpretation of the results, which is in conflict with this witness's testimony. So it's our belief that what the solicitor has done is ignored their test that they had performed, not a defense test, performed by NMS that gave the result of the compounds found in Mr. Scott's body, along with a written report by Susan Copcan, certified scientist, signed on April 16th of 2015 at 8:51 in the morning regarding the interpretation of those results. So this witness did not participate in the testing of the compounds, did not observe the testing of the compounds. We believe, therefore, it has a cooperative issue involved. Now this witness, regardless of the people who did the testing, has come up with a new interpretation that has not been previously provided to the defense that contradicts the testing that the state witness, first state witness, interpreted. It's a shock. The state appears to just be seeking the results that they want from as many different parties as they can. This is the report, and it contradicts what this witness states.
In response by the state.
I don't know of any contradiction in this witness's testimony versus what's in the reports. And as far as the rules go, Your Honor, under Rule 703, as an expert, Dr. Garvin can rely on the reports of others, and Mr. Savage certainly didn't have a problem with Dr. Porras relying on it. This is what they do. This is how the information gets to the pathologist, and the pathologist incorporates it into their autopsy results. All of the things that Mr. Savage raises are fodder for cross-examination.
The difference being I don't have a report from this witness. I have a report from Dr. Farmos. I knew what she has done. If I knew that this witness is going to testify in contradiction to the previous report, I would have brought in another. I would have brought the witness in from Philadelphia. We've exchanged expert lists. There's nothing that we have that the solicitor doesn't know about.
That's certainly not true, and we've had that discussion as recently as lunch. There are many things that they have that we don't have and that we aren't able to see.
And
But
we understand the rule. If we're going to use it in our case in chief, we'll give her a report.
which is why we gave Mr. Savage Dr. Garvin's CV.
This is a motion in limine hearing, the purpose of which is for the court to rule on the question of whether Mr. Savage can cross-examine this witness, raising the question that Mr. Scott was a chronic cocaine user and suffered under a condition referred to in some areas as excited delirium. This witness has given no indication that she has any view or has any opinion well, I guess specifically, I can ask you, ma'am, based on the history that you've reviewed and the facts stated here in this hearing of a marijuana arrest 30 years ago, a discharge from a job in 2014, an 01 incident of possession or use of cocaine, and cocaine being in Mr. Scott's system when he died, do you have an opinion as to whether or not, to a reasonable degree of medical certainty, as to whether or not he was a chronic cocaine user?
No, sir, I do not.
And with regard to this excited delirium, are you familiar with that term?
Insofar as it is associated with cocaine, yes, sir.
And do you have any opinion, do you believe that you're competent to offer an opinion as to whether or not he suffered from that at the time of his death?
I don't believe I'm in a position to render an opinion on that.
Based on this hearing, the motion is granted, and counsel is to refrain from cross-examination of this witness with regard to contending or probing her on whether or not Mr. Scott was a chronic cocaine user and whether or not he suffered under excited delirium. The testimony does not meet the reliability test. Any response would be speculative. And of course, the jury would be instructed at the end of the case that questions asked by the lawyers is not evidence, but has been demonstrated during the course of this trial up to this point. Questions in the nature of testimony has been rendered, and in many instances in such a way that a court instruction would be meaningless in the face of the manner in which the questions are posed. I think that the state is directly on point to allow cross-examination would be, in these areas, would be more prejudicial than probative. And so I grant the motion.
I realize we ruled you on it, but I'd ask the court's indulgence to, I want to argue further, but I want to point something out to the record, if I may.
Sure. For the record, yes.
Dr. Garvin, are you familiar with testing for foreign substances in hair samples?
Yes, sir.
Are you familiar with testing brain samples that are frozen brain samples to test for foreign substances?
Yes, sir.
And is it accurate to say that the frozen brain sample would give a more accurate analysis of the compounds in the brain that would affect behavior than a brain sample that's kept in formaldehyde for some years?
I would say that that is, in my opinion, would be specific to the compound in question.
Yeah, and you'll be able to cross-examine her along this line. I'm specifically referring to the motion in limine. Yes, sir. All right. All right, well, we've earned a 3-minute stretch or something in the meanwhile, so we'll just take a 5-minute break and then hopefully bring the jury.
Yes, sir.
Witness testifying about defense examination.
Well, the gist of what I got from it all is that this witness did not do a report, and because she didn't, you have a Crawford violation because she should have done one and the state should have given it to you pursuant to Rule 5. Is that the gist of it?
Well, the Crawford is that she was involved in any of this, that she's testifying as a non-peer, as a non-observer, which is a Crawford violation. A separate grounds would be the failure to provide a report on proposed testimony in Rule 5. Set those to the side, then we have the issue of the solicitor's inquiry of this witness about defense testing, which we assert that she had the best attorney-client work product privilege report. I think the case law is complete. The state can't utilize or question defense.
We can stay away from the right issue questions.
All right. Let's bring the jury.
Present, Your Honor.
All right. Let's see. Have you?
I swore before.
Okay, if you'll.
Your Honor, the state calls Demetra Garvin.
All right, you'll be resworn.
You swear affirm the testimony you shall give the court, the jury, and the trial in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Ladies and gentlemen, I mentioned to you earlier that from time to time we have to take up matters outside of your presence, and apologize for the long delay. You may proceed.
Please state your first and last name. That's my last name, Valley clearly.
Yes, my first name is Demetra, Demetra, Garvin, Garvin, and I'm commonly known as Demi, Demi, Garvin.
What's your occupation?
I am a forensic toxicologist and drug chemist, and also a quality manager.
And can you tell the jury a little bit about your educational background?
I have a Bachelor of Science in Biology from Furman University in Greenville, South Carolina, and I also have a doctorate in clinical pharmacy from the University of South Carolina College of Pharmacy in Columbia, South Carolina.
Do you have any training in the field of forensic toxicology?
Yes.
Tell the jury about that.
This is my 32nd year in forensic science, specifically in forensic toxicology and drug chemistry. And in addition to my undergraduate and graduate degree, I have many additional courses and continuing education events in pharmacology, toxicology, analytical chemistry, instrumentation, use and operation of the instrumentation that is associated with both of those forensic disciplines, and special lectures that also address those topics.
Now, back in the day, you worked for SLED. Is that right?
Yes.
Okay. And when was it that you worked for SLED, and in what capacity?
I began working in a part-time capacity for the South Carolina Law Enforcement Division's Forensic Laboratory in Columbia, South Carolina in 1984. I joined the laboratory in a full-time capacity in 1987 after I finished my graduate degree at the University of South Carolina College of Pharmacy, and remained with the State Law Enforcement Division's laboratory as both a staff toxicologist, clinical and forensic toxicologist, as well as drug chemist for the next 16 years, leaving them in 2000.
And were you certified by then?
Yes. Actually, there's no sort of state certification per se. There is an internal training program in addition to external training events that one must attend.
At SLED?
Yes.
Okay. And you left SLED to go to Richland County, is that right?
Yes, in the fall of 2000, I joined the Richland County Sheriff's Department in Columbia, South Carolina. where I established a forensic drug chemistry section and then went on to assist Sheriff Lott with the development of a full-service forensic sciences laboratory. I remained there in that capacity, in the capacity of drug chemistry supervisor, assistant laboratory director, and ultimately laboratory director for 15 years.
And now you're with the Forensic Science Network, is that right?
I've actually been with Forensic Science Network, which is a consulting firm in Columbia, South Carolina. We provide forensic services, principally forensic support services, principally toxicology and drug criminalistic services for coroners, pathologists, the law enforcement community, and the legal community. I've actually been with them since 2002. And I am also a quality manager with a firm known as DPX Technologies in Columbia, South Carolina. DPX stands for Dispersive Pipette Extraction Technology. It is a technique that was patented by one of my colleagues and essentially allows for the extraction of various substances from different materials in the pharmaceutical industry, clinical laboratory medicine, forensic medicine, and food safety.
In your time as a forensic toxicologist, do you have an idea of how many cases you've handled in your career?
Thousands.
And have you been qualified as an expert in the field of forensic toxicology?
Yes.
And do you know how many times you've been qualified as an expert?
Over 200.
Your Honor, this time we'd offer Dr. Garvin as an expert in forensic toxicology.
She's been as an expert.
And Dr. Garvin, can you tell the jury what forensic toxicology is?
Forensic toxicology is the study of alcohols, drugs, and other poisons, their identification both qualitatively and quantitatively in biological specimens that are obtained from both living and deceased individuals, the interpretation of those results both within the laboratory and perhaps in a court of law as requested.
Now, you mentioned earlier that the Forensic Science Network that you work with now sometimes assists coroners and pathologists in doing their work. Is that correct?
Yes.
Tell the jury how that works, what FSN and what you do to help assist pathologists.
Forensic Science Network, or FSN, was established in 2002 for the purpose of providing forensic support services to the coroners, pathologists, law enforcement community, and legal community here in South Carolina. The company functions to assist those groups in obtaining toxicology and criminalistics testing in both living and deceased individuals for the purposes of assisting in identifying the proper testing that should be performed, serving as a resource for both the literature and interpretation in casework, and perhaps offering testimony as needed. The casework can be specimens, toxicology specimens in particular, can be collected from individuals in the absence of an autopsy, but also during the time of autopsy. The biological specimens are then sent to an identified laboratory for testing, and Forensic Science Network works in conjunction with that laboratory to identify the best testing, and also with the pathologist and coroner to identify the most appropriate testing for a given situation, and then assist in the interpretation of those results.
And in this case, with the autopsy of Walter Scott, a blood sample of his was sent to NMS Labs. Is that correct?
There were actually two blood samples that were collected from Mr. Scott and were sent to NMS Laboratories, yes.
And so NMS Labs did the testing, came up with the levels, and then you help interpret that?
Correct.
Okay. In this case, can you tell the jury what the levels were that what the levels were in Mr. Scott's blood with regards to any narcotics or alcohol?
There were 2 samples of peripheral blood that were submitted to the laboratory for testing. The testing, the code that was requested was an 8052B. The B stands for blood, and that testing, the scope of that testing includes alcohols, one of which is ethanol or drinking alcohol, a host of therapeutic drugs, as well as drugs of abuse. Following the testing on the peripheral blood sample, there...
Let me ask you this before you get into what the levels were. You mentioned that 2 vials of blood were collected and that it was peripheral blood. Explain to the jury what that is and how that can affect things. Peripheral blood, that is.
Peripheral blood, the term peripheral in the context of a blood sample taken in the case of an autopsy or even in the absence of an autopsy, typically, in my experience, is associated with a blood sample that is obtained as far away from the chest cavity or upper chest area, the area on or about the heart and lungs. And very often a peripheral blood sample is obtained from a femoral vessel in the groin area or in the lower portion of the body. The reason for that is that there are a number of drugs that if they are present in the body at death, on or about the time of death, after death, there is the possibility that the drug will move from an area of high concentration to low concentration, and depending on where the sample is drawn in the upper chest area, could yield potentially a falsely elevated result. So we like to train and instruct individuals who collect specimens of blood for drug and alcohol testing to obtain samples of blood from as far away from the central portion of the body or the chest area as possible. That can be further complicated in the case of trauma, such as a motor vehicle accident, where samples could potentially be contaminated and, again, yield falsely elevated concentrations.
But in this case, we had peripheral blood, so that was a good thing.
Yes, that's correct.
All right, so the peripheral blood was tested, and the results were what, as far as the levels go?
The peripheral blood sample was tested for the compounds or classes of compounds that I testified to earlier. And during that testing process, there were 3 compounds that were identified, subsequently quantitated or associated with concentrations and reported. And those were cocaine in the amount of 36 nanograms per milliliter, cocaethylene in the amount of 26 nanograms per milliliter, and benzoyl econine in the amount of 1,300 nanograms per milliliter.
Okay. Can you say whether or not the cocaine level of 36 nanograms, is that a high level?
I guess I would have to say with respect to what?
Right. So in lay terms, when we say someone had a high level or a low level, that's sort of meaningless because you don't necessarily have a benchmark, right? Correct. And in South Carolina, for example, we have blood alcohol levels that we use to determine if someone is under the influence of alcohol for a DUI or felony DUI or something like that, right?
Yes.
And do we have that sort of benchmark for cocaine?
With respect to impairment? No.
Okay. So we don't have, like with alcohol, we can say at 0.08 under the law, someone's under the influence. We don't have that sort of level by statute in South Carolina. Is that right?
That's correct.
Okay. So we have this level 36 nanograms of cocaine, and then you said cocaethylene. Is that right?
Yes.
26 nanograms?
Per milliliter, yes.
Okay. Tell the jury what cocaethylene is.
Cocaethylene is a compound that is formed in the body when cocaine and alcohol, that is ethanol or drinking alcohol, is when the two of those are present in the body in circulation at the same time. It's actually a compound that is formed only when those two are present at the same time in the body.
Okay, so we have this cocaine alcohol compound, correct?
Yes,
But we don't have alcohol in the sample.
correct.
Okay, what does that mean?
That suggests, well, it is certain that at some point prior to the collection of the specimen, Mr. Scott administered or was administered alcohol. But at the time that the specimen was collected, there was no more alcohol, suggesting that whatever the original dose was had had sufficient time to be metabolized or burn off and otherwise yield a negative result.
Okay, and then the benzo, which I butcher every time. What is that?
Benzoylecgonine, I'll refer to it as BZE.
Okay,
It's a lot easier.
BZE. What is that?
Benzoylecgonine is a compound that is both a metabolite or breakdown product, if you will, of cocaine, but it is also referred to as a chemical hydrolysis product of cocaine. It has kind of a twofold existence, if you will. It is an inactive metabolite, meaning it doesn't contribute to the pharmacologic action of cocaine, but it can arise after cocaine use in the body by being both broken down by enzymes from the liver, but also it can arise spontaneously both in the body and also in vitro or in a specimen container or collection device over time if the proper conditions in the environment exist.
From these levels, can you tell anything about the route of administration? Is that the proper term?
The route of drug administration?
Right.
No, ma'am.
Okay. Explain to the jury what we mean when we say the route of administration.
In the case of cocaine, cocaine can be and has been used by many, many different routes of administration. That is the way in which the drug is introduced into the body, to include oral administration, smoking of the pure form or crack form of the drug, nasal insufflation or snorting, as it's commonly referred to, intravenous use, rectal use. It can be transmitted through the umbilical cord and during pregnancy and also through breast milk.
So when you get levels from this sort of testing, the levels are the levels and it just doesn't tell you how it gets into the body?
I'm not able to determine that, no.
From this kind of test?
Correct.
Okay. And these levels, what do they tell you about pinpointing the timing of the ingestion of the cocaine and alcohol?
I'm not able to determine a time of exposure to the drug either.
Can you give a window?
Could be hours, could be several days.
Can't narrow it any further than that.
No, ma'am.
Why not?
Again, because the breakdown of cocaine is very complex. It can occur both in the body as well as in vitro or in the collection device with time. It can also, we also don't know the dose, the route of administration, or the time of use.
That's all the questions I have. Please answer any questions.
The defense?
Thank you. Good afternoon.
Good afternoon, sir.
Dr. Garvin, would it be fair to say that the reason to extract peripheral blood is to determine whether or not a chemical contributed to the death of the person who it came from.
Yes, that can be a reason. Yes, sir.
And is that what was done in this case?
Yes, I would say that the purpose for the collection was to determine whether any alcohols, drugs, or other poisons could be present.
Contributed to the death of Mr. Scott, correct?
Well, that would be a decision that would be made by the pathologist.
And in this case, there was peripheral blood extracted from Mr. Scott, and it was done correctly. Is that correct?
Yes, it is a peripheral blood sample. Yes, sir.
And the peripheral blood sample was sent, was it sent to you or to SLED, or who was it sent to?
It was sent to National Medical Services, or NMS Laboratories in Willow Grove, Pennsylvania.
And where's your laboratory?
My office is in Columbia, South Carolina.
And are you a forensic toxicology person that could examine this blood had it been sent to you?
At the time that this was sent to me, no, I did not have a laboratory. No, I was involved in the interpretation, not the testing itself.
Right. But prior to your current location, you worked for SLED?
Yes.
For many years?
Yes.
And did you undertake an examination of blood samples at SLED at that time?
Oh, yes, sir.
But this particular sample was sent to, did you say Philadelphia?
Willow Grove, Pennsylvania.
Pennsylvania. And I'm not sure whether you testified about this or not, but does the time from the time of death to the time of extraction from the peripheral blood make a difference?
I'm not sure I understand the question.
So if there was an extraction at the time of death, if somebody died in a hospital and you took blood at or about the time of the death, and then you compared it to blood taken 24 hours later, would it make a difference?
Again, I'm not quite sure I understand the question.
It's the same question that the solicitor asked you earlier.
I don't think so. I'm sorry. I'm not sure. I don't think so.
You don't think it would?
No, I don't think it's the same question.
Oh, so what is the answer to my question then?
Well, I'm not sure I understand your question. I apologize.
Does cocaine break down after death?
Yes.
If cocaine breaks down after death, the timing of the extraction would make a difference then in the amount of cocaine that's found in the sample.
I'm not sure if I understand the use of the term extraction. I'm not sure how the use of that term in the question.
If a phlebotomist had a needle and went to my veins, they would extract blood, would they not?
Yes.
That's the connotation of extraction that I'm referring to.
All right, sir. Could you ask the question again then?
Sure. Does the time of the extraction post-death make a difference in the amount of compound, cocaine in this case, that would be found in that blood?
As the postmortem interval increases, the time from death to the sample collection, the blood sample collection, it is possible that in the case of cocaine, it could make a difference in the amount of cocaine that is present.
Because after life, cocaine continues to break down in blood.
Yes, it can. That's correct.
And so time is an important factor.
Yes.
And in this case, the time between death and the extraction was what, then?
I believe it was approximately 25 hours.
And does the cocaine then continue to break down after it's extracted?
Yes, it can.
And how long was it between the time that the cocaine was tested in the laboratory?
The specimen was collected on April the 5th, 2015 at 11 a.m. The report was issued April the 16th, 2015 at 9:02 a.m., so the testing would have been done between April the 5th and April the 16th.
Well, if it was done on the 16th, it would continue to erode. The compound of cocaine would continue to diminish till April 16th, correct?
It's possible, yes, sir.
And if the cocaine was examined in the laboratory on April, what day did you say they received it?
The specimens were received by the laboratory on April the 7th of 2015. So the testing would have been performed between April the 7th and April the 16th when the results were reported.
So for the benefit of the jury, would you give them the exact date and time that it was examined?
The testing would have been, there would have been multiple tests that were performed, and I don't have those dates. I just know the bracketed times.
So then we just have to guess that how accurate this particular testing was with respect to the concentration of cocaine in the peripheral blood taken from Mr. Scott.
No, sir, I would disagree with that.
Did you say that the cocaine would continue to break down as days go by?
It's possible, yes.
It's not possible. That's what happens. Correct?
It's possible.
What you say possible? Why do you say possible?
Well, because there's no way to predict the extent or the degree to which cocaine breaks down. It was in a preserved tube, so there will be some retardation or slowing of the breakdown, but there is also the possibility that over that time period, some of the cocaine spontaneously broke down.
And, do you have the report from NMS?
Yes, sir.
And again, that was done by a laboratory in Pennsylvania.
That's correct.
And they sent a report to you that you have testified about earlier regarding the quantity of those compounds in Mr. Scott's blood.
That's correct. Yes, sir.
And they also sent to you their interpretation, not your interpretation, but their interpretation. And actually, the solicitor was kind enough to send us a copy of that report. Do you have that report?
No, I'm unfamiliar with any interpretation that the laboratory performed. I'm not aware of any report that they issued regarding this case.
You have a report in front of you that you testified from, giving us the date that the specimen was received by NMS of April 7th.
The report's actually April the 16th of 2015.
The question I have is, do you have a report in front of you that said the specimens were received by the lab on April 7th?
Yes, I do.
And that's how you derive the date you talked to the jury about?
Yes, sir.
And you have a report, the same report that was issued on April 16th at 9:02 in the morning.
That's the first page of the report. I think we're speaking of one and the same document.
And it's interesting, in this report, it gives the exact date and time that the report was issued,
Yes, sir.
at 9:02 in the morning of April 16th.
That's correct.
Yet we don't know the date and the time of the testing.
No, that would require a review of the analytical data itself.
And did you do that?
No, sir.
Now, that report you read from is on page 1 of how many pages?
3.
And you have page 2.
Yes, sir.
And does page 2 interpret the amount of compounds found in the blood?
No, sir.
What does page 2 do?
Page 2 functions in several different ways. Number one, it provides what we refer to as detailed findings across the 3 substances, in this case, the cocaine, the cocaethylene, and the benzoylecgonine, providing the concentrations that were identified in the testing or determined in the testing, the associated reporting limits, which are the lowest limits of concentration, if you will, that the laboratory detected in association with these compounds or is capable of detecting for purposes of reporting, the specimen source, which was peripheral blood, and then how the analysis, specifically what instrumentation was used to perform the testing. In addition, page 2 provides what we refer to as reference comments, which are general comments across the 3 compounds that were identified to serve as resources for the reader of the report. And then the report also denotes the county of origin, which in this case was Charleston. And then page 2 was also digitally signed by the certifying scientist at National Medical Services who reviewed the data and the report and issued the report.
So page 2 of this 3-page report is a signed document interpreting the findings by Susan Crookham, who is the certifying scientist. Is that correct?
Yes, she signs the report after reviewing the results.
And were you involved in any way in the laboratory testing of Mr. Scott's blood?
No, sir, I was not.
And in this report from, is it Crookham?
Crookham?
Crookham? Does she say in paragraph 3 that Ecryl 9-methyl ester can form from cocaine breakdown after death and even after sample collection?
That is a statement that is on the report. It is, yes, a reference comment that is provided.
Well, you've had this report, correct?
Yes, sir.
And you haven't issued any report ever in this case, have you?
No, sir.
And so you've had this report, you've had opportunity to review it, to examine it, to look at the, what do you call that, the lab notes that the scientists keep as they're doing the examination. You could have examined any of that stuff.
If I'd been asked to do so, yes, sir.
Did you actually, you talked to Susan Crookham, did you?
Did I talk to her in this case?
Yes.
No, sir.
So you really don't know anything about this specific case, you're just talking based on your general knowledge of science.
No, I would disagree with that, sir.
Well, let's look at the breakdown of the 3 substances. Did you call it BEZ?
I referred to it by a common acronym, BZE, or benzoyl-ecgonine.
I'll refer to it as BCE as well. And the amount of BCE found in Mr. Scott's blood up in Pennsylvania, sometime between the 7th and the 16th of April, was what?
1,300 nanograms per milliliter.
And you had indicated that your history, you were a DUI specialist, and alcohol, the various percentages of alcohol in one's blood to determine whether or not they were drunk or impaired in terms of driving in South Carolina. Is that correct?
Yes, that is a component of a forensic toxicologist's work.
Did you notice in the report from Susan Crookham that people admitted to an emergency room for cocaine-related medical complaints was 1,280 nanograms per milliliter?
I'm sorry, could you point me into the area?
Does the report that you have, page 2, refer to the amount of BCD or whatever it is in one's blood that report to emergency rooms for cocaine-related medical complaints were 1,280?
Yes, I see that on the report.
So people who report to hospitals for medical assistance resulting from cocaine use have a lower concentration than what was found in Mr. Scott's blood.
They can.
Well, that's what the report says.
Yes, comparatively, that is true.
Are you saying that these people in Philadelphia in some way interpreted this report to favor one or the other sides in this case?
No, sir.
And that same report says the average blood BCD concentration in 906 impaired drivers was 1,260 nanograms per milliliter.
Yes, it does say that under the reference comment.
Again, this is the opinion of somebody up in Pennsylvania, correct?
Well, I would say to you that these are reference comments. For the record, they are not interpretive comments associated with this case. They are reference comments for resource only.
Whatever they are, if this jury has the opportunity to compare the numbers, the number of 1,300 is what was in Mr. Scott's blood, and the drunk drivers across the country have 1,260, according to this report.
That has been reported. Yes, sir.
And the people who go to hospitals for cocaine use-related medical problems has a lower concentration than Mr. Scott had.
They can have lower and they can also have higher.
But the average person who goes to the hospital for cocaine medical-related issues has a lower concentration than Mr. Scott did.
No,
Is that correct?
no, sir. That's not correct.
All right, well, what does that mean then? That concentration in patients admitted to an emergency room for cocaine-related medical complaints were 1,280 nanograms per milliliter.
That is a reference comment that is taken from a study for purposes of being imported into the report. That is one snapshot in time from one study. There is significant overlap between therapeutic, toxic, and lethal concentrations of both cocaine and benzoyl-ecgonine in the literature.
But this report is the state of South Carolina's report. This isn't a defense document. This is something that the state of South Carolina sent this blood to Philadelphia or somewhere in Pennsylvania and received a report from an independent party who has a scientific background that you deal with all the time.
That is correct.
So you're not contesting the authenticity or the truthfulness of this report, are you?
No, sir.
The report on page 2 gives the reader, and in this case the reader would be the jury if they were given that report, effects following cocaine use can include euphoria. Is that correct?
Yes, sir.
Excitement. Is that correct?
Yes, sir.
Restlessness. Is that correct?
Yes, sir.
Risk-taking. Is that correct?
Yes, sir.
Sleep disturbance. Is that correct?
Yes.
And aggression. Is that correct?
Yes.
Now, with respect to this case and your participation in this case, you were not at the corner of Remount and Craig Street on April 4th, 2015, were you?
No, sir.
You did not have an opportunity to observe the behavior of the driver of the 1990 Mercedes that was stopped for a broken taillight, were you?
No, sir.
You have, however, I'm sure, heard about the behavior of the driver who was driving that 1990 Mercedes automobile after he was stopped?
No, sir.
You don't know anything about his behavior?
Not to any significant degree, no,
So
sir.
you're not in a position to say whether or not his cocaine ingestion and the levels that were found in the lab analyses contributed to his behavior that day?
No, sir. There are elements that are missing in order to be able to deduce that.
Now, what are those elements?
Well, those include dose, frequency of administration, route of administration, and the number of exposures that Mr. Scott would have had to cocaine.
Such as how often he had used it in the past?
Potentially, yes, sir.
That would be an important factor in the interpretation of the blood?
Yes, could be.
Hair can be examined for substance abuse.
Yes, it can.
Was it done in this case?
No, sir, it was not.
Do you know who had possession of the hair from April 5th, 2015 to November 8th, 2016?
No, sir, I do not.
Just have one question. I always say this, but I really have to hear the end.
You had indicated earlier that you couldn't tell exactly, based on the laboratory findings of nanograms of the compound, in this case cocaine, per milliliter, you couldn't tell just from that information when the cocaine was taken by the person. Is that correct?
That's correct.
And that's because we don't know the dosage and the frequency of use of cocaine of that person.
Those are two elements. There are other factors that impinge upon that, but those are two. Yes, sir.
But we do know scientifically the half-life of cocaine. Isn't that correct?
I'm sorry, could you ask your question
We
again?
know, and again, I want to do this in a way you can instruct the jury. You can tell the jurors that they can analyze these numbers if they know the half-life of cocaine.
No, sir, I would not tell the jury that.
For what reason?
Because I wouldn't be able to do that.
We'll take a look at the report, page 2. And does this report give us the half-life of cocaine?
Could you point me to where you are referring?
Well, what do you understand the half-life of cocaine to be?
Well, it's dependent on, in part, the route of administration. So because I don't know the route of administration in this case, I can't tell you what the half-life is or even provide a suggested half-life.
So that would mean whether it's snorted or whether it's mainlined with a hypodermic needle or whatnot?
That's correct.
Now, you do know from BCD the half-life of that, correct?
The reference comment does provide a half-life of 6 to 10 hours for benzoyl-9. Yes, sir.
And so can you take the number of that product and then extend that back in time to tell us the parameters of when it was used?
No, sir.
And on the cocaine, regardless of the dosage or the frequency of use, is there scientific literature that will tell us the half-life of cocaine?
There is peer-reviewed literature, scientific and medical literature, that provides half-lives for the drug under specific conditions.
And what would those conditions be that would affect the half-life?
Well, dosing, the route of administration, whether or not you're dealing with single dose or multi-dose, times of collection, reporting limits, the type of instrumentation and reporting limits, all those things would be factors that would surround reporting of that type of information.
And the answer to those questions could be found in the hair follicles of Mr. Scott. Isn't that correct?
No, sir. I would disagree.
So hair follicles would have a history of drug usage, correct?
It's actually the shaft of hair that is tested, not the follicle. And for purposes of cocaine, depending on the method that is used, it is possible to establish or obtain some information about cocaine exposure from the hair.
Assuming that we don't have those numbers for the jury, we do know from the numbers, we can tell the jury that there was more BCD in Mr. Scott's blood than the average drunk driver. Correct?
No, sir, I wouldn't opine that.
What does the report say the amount of BCD in the average drunk driver is?
It gives an average of 1,260 nanograms per milliliter with a range of 5 to 17,600 nanograms per mil.
So I heard the solicitor, it doesn't say drunk drivers, it says impaired drivers, correct?
Yes.
Impaired drivers are those who are convicted for DUI in South Carolina. And the amount in Mr. Scott's blood exceeded the average amount of an impaired driver.
In this
According to this report from the folks in Pennsylvania.
In this particular study that was quoted, yes, that's correct.
In this particular case of the death of Mr. Scott and the trial of Mr. Slager, in this specific case, that's the report that was received from Pennsylvania.
The report was, for benzoylecgonine, was 1,300 nanograms per milliliter, yes.
Thank you, Dr.
Redirect.
BZE, that is not something that impairs a person, is it?
Objection to the formal question.
It's an inactive metabolite, which means it.
Objections
I'm sorry.
overruled.
What is BZE?
It's a breakdown product and inactive metabolite of cocaine. It has no pharmacologic action.
Inactive metabolite?
Yes,
you said?
yes,
It doesn't have an effect pharmacologically on a person?
that's correct.
So this 1,300 level that Mr. Savage mentioned with regards to people who have been admitted into the hospital, that can't tell you how impaired a person was.
That's correct. It merely indicates, well, it indicates several things, but the first of which is that the individuals in the impaired driving study were had previously been exposed to cocaine.
At some point.
Correct.
Now, with regards to cocaine, the report gives similar stats regarding cocaine, which can cause impairment, right?
Yes.
Okay. And what was the average level of cocaine in the blood for impaired drivers admitted to the hospital?
The average blood cocaine concentration quoted in that study in 906 impaired drivers was 87 nanograms per milliliter with a yes.
87?
Correct.
We have 36 here?
Yes.
then those who went to the hospital and complained of a cocaine-related problem in that study, what was their average level?
I'm sorry, are you referring to the next statement that's published? Those individuals who were admitted to an emergency room for cocaine-related medical complaints, the average blood cocaine concentration was 260 nanograms per milliliter.
260.
Yes.
And in this case, we have 36.
Yes. But I would add that in both of those instances, the individuals were living, whereas in this particular case, we were dealing with a deceased individual.
Let me show you what's been marked as State's Exhibit 242. Is this the report you've been referring to for your testimony that Mr. Savage referenced with you?
Yes.
Your Honor, just tell me now for State's 242.
Says the defense.
No objection to the 3-page report.
It's admitted without objection.
Now, you were also questioned about this time gap between autopsy, when the peripheral blood was collected, and the time that the testing was done. At most was about 11 days, was that right? Because the report was done on the 16th?
The report was issued on the 16th, and the specimens were received by the laboratory on the 7th of April, 2015, but they were collected 2 days earlier on the 5th, so approximately 11 days in total.
And when they're collected into these gray top tubes, does that have any sort of preservative in it?
Yes, it does. It has sodium fluoride in it as a preservative.
Does the preservation process help with that breakdown of the substances?
It does to a certain extent. In short, it does retard the degradation of cocaine by some of the routes of degradation, but not all of them. So it does not completely retard the breakdown process, but it does to a certain extent.
And in your field of forensic toxicology, NMS Labs does hundreds, if not thousands, of testings from autopsies in South Carolina.
Oh, I would say thousands, hundreds from Forensic Science Network.
Okay. And is it unusual for it to take 11 days for a specimen to be tested and a report to be issued?
No.
And does the 11-day, I'll use the word delay, is 11 days a delay?
It's yes, in the classic sense of the word, it's a delay. It's the time it takes for the specimen to be processed and then analyzed and the data to be reviewed and reported.
Do you and other forensic toxicologists rely on reports and tests that have been done in 11 days or more?
Yes.
And is that unusual?
No.
Does it cause you any concern about the quality of the results?
No.
Why not?
Because the type of testing that was performed analytically, the manner in which the specimen was collected, and the scope of the testing, in my opinion, appeared to be appropriate and supported by the results.
That's all I have, Your Honor.
Anything further? Thank you. You may step down.
Thank you, sir.
Next witness.
State of Don Clayton.
Stand for a moment.